Assalamualaikum warahmatullahi wabarakatuh. This is part 2 for the Zoom recorded lecture for the topic Promissory Estoppel. So in part 1, we have covered the introduction as well as the first feature of the doctrine. Now we want to proceed with the second feature. The second feature of Promissory Estoppel is that representation or promise or encouragement must be clear. Okay, that's the word, must be clear, and it must be unequivocal. We have the case of Hong Leong, Lee Sing, Semberhat, and Tan Kim Cheong reported in 1994. Let's have a look at the facts of the case here, the summary of the facts here. The plaintiff claimed a sum of money under a hire purchase agreement. Basically, the claim is based on breach of contract. But the strange or the odd or the unique part of the case is that, unlike any other cases of hire purchase, in this particular instance, as far as the case was concerned, actually the real fact was that the subject matter of the agreement, which is the machines, actually never existed. And then in relation to estoppel, usually in ordinary cases of estoppel, most of the time, it is used by defendant as a defense. But as far as Hong Leong case, Hong Leong Lee Sing Semberhat is concerned, estoppel is raised by the plaintiff. What's the purpose? To defeat a possible defense of the defendant. So in other words here, estoppel in this case is used, is applied not against a plaintiff, but now it is used by a plaintiff. But the reason is that for the plaintiff to defeat any possible defense by the defendant. So this is part of the relevant judgment. The court said that in the law of hire purchase, because it revolves around hire purchase contract. So in the law of hire purchase, it is sometimes that said that the hirer may be stopped from raising the issue of non-existence of the goods, because the hirer himself had represented to the financier, because financier is the one who make the payment. Because he made representation, he already had possession of the goods. But again, in order for estoppel to arise in such a situation, the court will look at all the situations. The court will examine the statement made by the hirer, and the goods had been delivered to him. All the statement here, it must be very clear. Must be very, very unambiguous, no ambiguity whatsoever. And actually, the case fulfilled this particular requirement. So estoppel was being allowed, was being raised, it was being pleaded by the plaintiff. You can have a look. I mean, you need to read the full facts, in order to know why, why the party managed to plead estoppel, and then why the machine was never in existence, because it involves certain agent here. It involves many parties. That's why the financial wasn't aware that the machine never existed, because there was certain representation, assurance given by the agent that the machine actually had been delivered, whereas it never been delivered. We go to the third feature. Estoppel may be applied, may be relevant in the case, in situation where even though there's no pre-existing legal or contractual relationship between the parties, between promisor or promisee. Because normally, usually in most cases, the parties, promisor, promisee, have already earlier relationship, legal relation between them, earlier contract between them. But because the doctrine is very, very flexible, that's why it is also applicable in case where there is no pre-existing legal or contractual relationship between them. Here it is applicable for both, even though normally there was contract between them. But even if there's no contract between them, still, estoppel can be applicable, can be used. We have the case of Cheng Han Guan and Perumahan Farlim Semberhat here, reported in 1993. The plaintiff were the tenant. The plaintiff claimed that they were and are. They were in the past and at present. When the case was brought to the court, were and are lawful and protected tenants, and that's why they claim that they were entitled in law and also under equity to what? To possession. They possess certain portion of land because that's where situated their dwelling houses, two dwelling houses, and also their vegetable farm. And actually, the proprietor, the registered proprietors of the land, they are the trustees of Ku Kongsi. And then plaintiff actually had converted, before they occupied the land, it was a swampy jungle. When they occupied the land, the plaintiff converted this swampy jungle land into productive farm. That's why the value increased lah. It become high in value. And then the visiting trustee of Ku Kongsi actually, they told plaintiff, they told that, okay, not necessary to change the tenancy of the vegetable plot to their name. No need to change their name whatsoever. And then there was assurance promised by the visiting trustee here. The promise was that they could, plaintiff could continue planting vegetables as long as they wish, provided they paid rent. Yeah, you can stay here, you can plant the vegetables as long as you keep on paying the rent. So this is an assurance, a promise given by Ku Kongsi that as long as plaintiff continued to pay ground rent, plaintiff could stay and cultivate the vegetable plot as long as they wanted. Here, there's no specific duration or time, tenancy period here. And then later they have problem. After the assurance given by the visiting trustee, plaintiff invested a big amount of money, 12,000, to install a sprinkler system. To upgrade their vegetable farm here. And then the assurance given to plaintiff is consistent with the practice of Ku Kongsi. And later, the problem arose because developers of Falim came to the scene in the late 70s. They wanted to develop the land. And then actually, for more than 50 years, the plaintiff had been staying there. Neither Ku Kongsi or anyone else had interfered with the farming activities of the plaintiff family. So problem arose when Ku Kongsi entered into a JV, joint venture agreement. And later, that's why the Perumahan Pali now wanted to take possession of the land. So it affects the plaintiff possession over the plot, for the vegetable farming and also their dwelling house. So now the plaintiff actually was relying on the doctrine of Promissory Estoppel, and the court observed that doctrine of Promissory Estoppel, it provides a defense to an action on the original contract for a defendant relying on voluntary variation. And then actually, how does it operate? It does not provide a cause of action for a plaintiff relying on gratuitous promise. But then again, we look at the effect here. The effect is that it may be to enable a party to enforce a cause of action which without estoppel would not exist. So basically, did the court allow the plaintiff claim based on estoppel here? The pleading of the doctrine here. Yes, the court allowed. Plaintiff claim was allowed by the court. So they could stay there as long as they paid the rental. We have another case which is quite recent, compared to earlier case. This one reported in year 1993. We have the case reported. This is MLJU unreported, but relevant for our discussion. 2015. Harban's car, anak perempuan Kesar Singh, swing as beneficiaries of the estate of Mahinda Singh, anak lelaki Nika Singh, is a long name. And they are actually, the suit was against associated, I think it's quite a famous company, Associated Pan Malaysia Cement Sdn Bhd. What happened here? Plaintiff, they sought a court declaration that they are lawful occupiers of a bungalow built on land. The land was leased by Selangor government to the first defendant. And who was the first defendant? The first defendant was the registered mining leaseholder of a mining. The land was used to do mining, mining activities on the land. So now they wanted to, defendant wanted to recover vacant possession of the bungalow, with a view to demolish it to complete a river diversion scheme. But the plaintiff said no, they have been staying on the land, they have been occupying the land, they have been occupying the bungalow. They were the lawful tenants before. Before the lease was granted to a new lessee. The lessor is the government of Selangor, state government of Selangor. And what's the argument? Plaintiff contended that they have the right of occupancy of the property because why? They had incurred expenses in maintaining and upgrading the property. And as far as estoppel was concerned, how it is relevant for our case here? It was argued that defendants are stopped on the basis of promissory or even equitable estoppel in denying the plaintiff right of occupancy. Meaning they have rights to occupy the land and their rights prevail over the new lessee because now the lessee is taking over the possession not really ownership, possession. So it's a long case, but it's worth reading actually. Here the case. Now let's move to the fourth feature of Promissory Estoppel. Promisors Act has influenced the promisee because it's between the two parties. Promisor, promisee. Promisor is the one who promised towards the promisee. So what is the Promises Act? Promises. What is the promisee's response? So actually, promisee Act respond based. It influenced the promisee. The act of the promisee is influenced by the promise by the promisor. Okay, so promisee must prove that he was influenced or induced by the conduct of his opponent to act in a particular way. And then actually, if we were to trace to the early development of the doctrine, one who relies upon estoppel, he must prove that he had altered his position for the worse, meaning that he suffered certain losses or detriment. But that's the earlier development of the doctrine. But later, actually, as far as Malaysian position is concerned, federal court said that the detrimental element does not form part of the doctrine of estoppel. There's no need to prove elements of detriment. It doesn't matter whether the one who seeks the protection under estoppel has suffered losses or detriment or not. So long all other features are fulfilled. This is actually taken from the earlier case that we discussed, Basket Trading and Arab Malaysian Merchant Bank Berhad involving factoring agreement. Okay, so again, in relation to detriment here, detriment is certain losses. Representative may have benefited from the representation, and yet it may be inequitable or at least without notice for the representative to enforce his legal right. This is, this is the rule that we extract from the case of Societe Italo-Belge pour le Commerce at Industry and Palm and Vegetable Oils Malaysia Berhad. Or the nickname for the case, because the case is so long, so the post-chaser case reported in year 1981. So in this case, the post-chaser, it involves certain sellers of oil palm. So sellers of oil palm, Malaysian company, fail for certain period, for over a month, to submit declaration of selling. And later, they finally did manage to submit. And then the buyers, on the other part, did not initially object and reply asking for more documents. And the buyers then sent declaration down the line to their own sub-purchaser. Meaning there's no objection of the buyer. They just accepted and they send it to their sub-purchaser. But later, sub-purchasers rejected the overdue declaration. And then only from there and then, the buyers tried to reject the declaration. And the seller now pleaded equitable estoppel. The case is more on equitable estoppel actually, but it still relates to estoppel. So because we want to focus on detriment actually, the court held that the person having made the representation which give rise to the claim of estoppel will not be allowed to enforce his rights where it will be inequitable. It is unfair, having regard to the dealings which have thus far taken place, whatever dealings earlier that took place between them. And the court made it clear that to establish inequity, it's not necessary to show detriment. No need to prove on the part of the promisee or promisor, the parties here, the one who wants to rely on estoppel, no need to prove elements of detriment. Okay, the number 5 is just a straightforward one. Representation, whatever promise by promisor towards promisee, it may be of facts related to facts, it may be of law. Both are included. So again, we are relying on the same case, Bourse Trading and Arab Malaysia Merchant Bank. So if you were to go to this back to the slide, okay, earlier slides number 13 until 17. So we stop here. We are going to continue in our part 3, okay, for the lecture.